Good afternoon. Thank you for joining us. I just wanted to do a quick sound check. If you can hear us and possibly see us, let me start the webcam up. There we go. Then write into the question box and let us know. Thanks. Hey, well, good morning and welcome to today's webinar. I'm Beth Hawley with the Arizona Realtors, and we're proud to bring you these free webinars designed exclusively to keep you updated on issues in the industry. Today's presentation will be about 30 to 45 minutes. If you have any questions during the webinar, please write them in the question box and we will try to get them answered at the conclusion. If you'd like to change the size of the webcam video, simply click on the line separating the webcam and the PowerPoint presentation and drag. As always, today's webinar will be recorded and available next week on our website at aaronline.com. So joining us today is Patrick MacQueen, Esquire, founder and partner of MacQueen & Gottlieb. Patrick's experience has been in the realm of real estate transactional law and real estate litigation, and he's here to talk about updates with the Airbnb and vacation rentals. So welcome, Patrick. Thank you for joining us.
Thank you for having me. It's quite interesting that in just 3 months' time, we've had quite a lot of updates, and we're going to go over those updates fairly significantly today. And they're fairly significant updates, and so it's an ever-changing landscape right now that has sort of been thrust upon us. So go ahead and change the slide there, and we can kind of, well, you don't need to see that, my bio there. But anyhow, in the April 2019 webinar, we went over a number of items, and we went over legal issues on the rise. And when I say legal issues, I mean pretty significant lawsuits, and they usually involve injunctions to stop somebody from using from Airbnb or short-term renting their home. And injunctions are court orders. It's a request that somebody stop using their home as a short-term rental. And so those are definitely on the rise. They're still on the rise. In April, we saw a lot of them. In July, right now, we're still seeing a lot of them. And injunctions that are filed by individuals or by HOAs, they're tough to win. You have to prove that there's irreparable harm if the court doesn't give you the injunction. That's a pretty tough standard, but people are still trying it, okay? Because some people don't like these Airbnbs and short-term rentals. We also are seeing and saw in April a rise in nuisance-based lawsuits. And a nuisance-based lawsuit is just what it sounds like. Hey, my next door neighbor is creating a nuisance by virtue of constantly renting out their house, constantly allowing parties to happen over there, constantly allowing cigarette butts and cigarette smoke and alcohol to be consumed over there at a loud volume. And therefore, I'm going to bring a nuisance-based lawsuit against my neighbor to get them to try to stop. Nuisance-based lawsuits, just like injunctions, are tough to prove and tough to win. Okay, and so what I'm trying to paint this picture of is Arizona is a very friendly landscape when it comes to short-term rentals. Okay, so injunctions, yes, they're on the rise, but they're very tough to prove. They're very tough to win. Nuisance lawsuits against somebody who has an Airbnb, has a short-term rental, yes, those are on the rise, but they're very, very difficult to prove and to succeed on. In a nuisance case, when you're suing somebody, you're suing your neighbor to get them to stop the nuisance, there are two standards. There's a subjective standard, meaning that this nuisance is bothersome to you, and there's an objective standard, which you have to show that it would be annoying to a reasonable person. So those are tough to prove. Okay, so we have injunctions on the rise, we have nuisance-based lawsuits on the rise, we have a rise in just basic neighbor disputes, right? And we see neighbors who are sending nasty letters to each other saying, don't do this, or your last guest did this to my house, I want you to pay for it. And so we see this, a little bit of acrimony, a little bit of animosity being built up in some of these neighborhoods. Some neighborhoods are just fine with it and understand that this is part of the economy now, but some other neighborhoods don't like it. We also see a rise in CC&R, covenants, conditions, and restrictions that govern HOAs or that govern properties. We see a rise in judges interpreting those, and usually they're being interpreted favorably to the owner of the short-term rental. Okay, so people are trying to push the issue. In certain CC&Rs, there's restrictions on using homes as hotels or using businesses, but courts are saying no. These are written in the 1970s, even in the 1980s. We're not buying it. This is not a hotel. This is a short-term rental, and I'm going to allow it. So we see a very, very friendly landscape. And what I'm going to talk to you as well about down in a few minutes is what Governor Ducey just signed, which basically says, look, continue this practice, continue what everybody's doing. There weren't many teeth to what he put into action. We'll talk about those. In April, we also discussed the short-term or the sort of history of or the origin of short-term rentals. We have evidence that these started in the 1600s with Louis XIV using certain hunting camps and giving them out to buddies. And then we have the evolution into England, where people were using vacation rentals and charging their vacation homes and charging their friends to use them for the night or for the week. In the mid-1950s, we're continuing to evolve. We start seeing more timeshares, advertisements in U.S. papers. We see the Vacation Rental Management Association being created. And then, of course, creation of the internet in the 1990s or so. And then in 2005 and 2008, Airbnb and Vrbo were created. And those were created for some interesting reasons. Vrbo, vacation or Vrbo, however you want to say it, was initially used by some ski bums in Breckenridge, Colorado, who wanted to get some use out of their home while they weren't there. Airbnb, something very similar. There was extra convention space, or they needed extra convention space or hotel space because the hotels were booked around a certain convention area, and so people started renting out their homes. And now we have, 34,000 cities. The average owner is getting 27,000 or so a year in revenue for these. We represent some folks who are getting $70,000 to $100,000 per property on these, and so it's changed quite a bit. It's now an $85 billion industry. Back in April, we also talked about some creative ways that people are getting either to avoid laws or to make even more money doing these. One of which was to create a party house. And the way that we've seen people make a lot of money is to sort of rent out a nice house, maybe in North Scottsdale, maybe parts of Tempe, Phoenix, whatever it is, and they charge a $100 guest fee to come in and party at this house. And if there's 200 people and get $100 a pop, well, that's $20,000 pretty quickly. And so really the only concern that the people have in those situations is that the police will shut the party down and charge a fine of $250 or $500. Well, that's a good business, I guess, for some people. And so we're seeing some uses that may not be, on the up and up by everybody. Another situation, another interesting thing that we're seeing a lot of are folks coming in from out of state, even within the state, and I don't want to say the word buy up, but they're getting apartment leases or home leases. So for instance, if a landlord is renting a home for $1,500 a month, and somebody comes in and says, hey, I'll rent this for a month, and then that person goes and assigns it to Airbnb or Vrbo and uses each of the rooms to make an additional $1,000 to $2,000 a month. And so on a single rental of $1,500 a month, somebody's netting $2,500 by not even being there and just knowing how Airbnb and Vrbo work. We're seeing this on a larger scale as well. So some people will come in to an apartment complex and say, I want an entire floor of units of apartments, and I'm going to use this for Airbnb or Vrbo purposes, and some landlords are allowing it. And so that is how people are making quite a bit of money. At this point, that's legal to do. Now you may have an assignment or sublease provision that says you can't do it, in which case you're kind of flirting with danger, but in most instances, as long as the landlord is not getting any extra trouble for you to Airbnb or VRBO the home or the apartment, it's definitely happening. Okay, and so that was one of the items that we talked about, whether that's okay to do or not okay to do. And at this point, there's no law prohibiting it. Okay, in April there were just two primary laws on the books pertaining to short-term rentals. And those laws basically said, number one, cities cannot restrict short-term rentals. They can't ban short-term rentals except for health and safety reasons. And counties can't do the same. They can't restrict short-term rentals, okay, except for health and safety reasons. Scottsdale and a few other cities had their own code amendments that sort of put a little bit of an extra restriction on short-term rentals at the time, but it was nothing significant, okay? And so we're going to talk about those new changes in the laws. The laws have been amended slightly. They were amended in May, 1 month after the prior presentation in April. We also talked about private restrictions and deed restrictions and HOAs and how HOAs play into this, okay? The law says that if an HOA can obtain the appropriate amount of votes and the vote is proper, an HOA can amend their CC&Rs to prohibit short-term rentals, or they can significantly limit short-term rentals. Well, there's some new case law on that as well, and we're going to talk about that. There's this grandfathering in concept, or this, I go in and I believe that I'm buying a property that allows short-term rentals. Subsequently, the HOA goes and amends the CC&Rs to prohibit me from doing that. Well, there's some courts in Arizona who have said that prohibition doesn't apply to those folks who bought to do short-term rentals. So there's sort of this grandfathering in clause. Not all courts are doing that, but there's a lot of them. Okay, so it's so just remember that private HOAs can restrict, but the restrictions may not be as strong as they originally thought. Okay, we also went over some tips to avoid a disaster. If you're an owner of a home or considering being an owner of a home that does short-term rentals, we had some tips. The first tip was to call these folks, call the folks that are using the property, call them licensees, call them guests, don't call them tenants. If you call them tenants, you may have to give them tenants' rights, meaning you may have to go through a formal eviction process if they won't leave on time, okay? Number two, put this property in an LLC, okay? You don't want to hang out there with your own liability, your own personal liability. Put the property in an LLC. Item three, the tip three was to verify local laws and CC&Rs before you decide to change into a short-term rental. And then the fourth bit of a tip was to always have a written agreement. Airbnb and VRBO will allow you to have your own supplemental written agreement. And in that agreement, you're going to want to have certain key terms. If anybody wants a copy of an agreement that we've written and we've used for other folks in the past, email me. I'll give you my email address at the end of the presentation. Okay, go ahead and change this one. Okay, so let's talk about, well, here are the teaching points for today. Number one, we sort of talked about these, but number one is going to be the new law that Governor Ducey signed into effect at the end of May of this year, which goes into effect in August of this year, at the end of August of this year. Second thing we're going to cover today is misrepresentation claims. And what I'm going to tell you is that these are on the rise. So if you as an agent know of a bizarre short-term rental scenario on a house you're selling, you may want to disclose that. You may want to have that discussion with your seller to disclose that. And I'm going to give you an example of where an agent goofed up and didn't make the proper disclosure and got a little bit burned on that. There are other states in the United States now that are requiring the disclosure of vacation rentals in connection with the listing. So statutorily, those states are saying, look, it's important that people who are buying into a neighborhood know that these can be used as short-term rentals. So we're going to have a disclosure obligation. I don't know that Arizona is going that far. I highly doubt it, but it's something to keep in mind. We talked about the grandfathering issue. We'll touch on that a little bit more. I want to go over some legal issues that haven't arisen quite yet, but I think they're on the horizon. And those primarily deal with the ADA and fair housing. And then I've supplemented that list that I just gave you of tips, and so we'll go over some new tips as well. Next one. Okay, so remember what I said at the beginning and in April, we really had two laws in effect, okay? Those two laws basically said, number one, cities can't do anything to restrict short-term rentals, and number two, counties can't do anything to restrict short-term rentals, okay? Those laws have largely stayed the same, but we have a slight amendment, and this amendment was approved by Governor Ducey, like I said, at the end of May. It goes into effect at the end of August. Now, owners must provide contact information, either the person who is managing the rental or contact information to themselves in case there's a late night party, in case there's a late night issue, and the owner needs to be contacted. Okay, not a huge requirement, but that needs to be taken care of now. There's also a series of fines. The first fine is $250 for non-compliance with these new statutes, up to $1,000 for non-compliance. Okay, the rule also says you can't use short-term rentals for special events. You need a special events permit, etc. These have to be rentals. They can't be, big catering events like weddings and those sorts of things. And you have to obtain a transaction privilege tax license because we want to make sure that the Department of Revenue is getting their shake on all of this stuff. The original draft of the bill that was presented to Governor Ducey back at the beginning of the year had quiet hours, so you had to be quiet in your vacation rental after 10 o'clock. It had a maximum of guests that could stay per room, and it had sound recording devices, or the requirement that folks install sound recording devices into their homes. Well, those were not popular, and so those items were left off the final legislation. So again, in my view, Governor Ducey basically didn't do much, right? He had the opportunity to do quite a bit more, but he chose not to. He wanted to say, like, Arizona's open for business. Arizona is friendly to short-term rentals, and we're going to allow this subject to these minor new restrictions and minor new items that they wanted to impose. So not much there, particularly compared to other states. Go ahead and change the slide. Okay. So I want to get in that misrepresentation issue because I think there is potentially a trend here, at least there has been in other states. So buyer is going into a house, they go and buy this house. They did not know that the two homes next to this particular house on both sides of the house were known as frat row and quite the big partier short-term rental houses, okay? Buyer goes in, buys the house. The neighbor across the street says, did you know that these were party houses when you bought it? Oh, no, I didn't. Did you know that the seller sold because they were sick of the parties? No, I didn't. Well, did you know that the listing agent actually went into your pool and had to pull out cigarette butts and beer bottles because the short-term rental houses, or those renting from those houses, were throwing their own beer bottles and cigarette butts into the house that was listed? And the buyer said, oh, no, I didn't. And so you can see why there would be a misrepresentation or a disclosure issue there, particularly if the agent was caught on video picking out cigarette butts and picking out beer bottles. And so I just throw that out there because that is something we've seen since April that agents probably need to know about, okay? And I mentioned in some of the Pacific Northwest states and on the East Coast, there's new legislation that basically says if you are aware of a short-term rental, or you're selling the home as a short-term rental, or your neighbor's with a short-term rental, that needs to be disclosed. Again, that's not the law. There's no statute in Arizona on that issue, but that may be the trend. Arizona, again, is extremely friendly to short-term rentals, okay? If you look at other big touristy cities, they're much less friendly, okay? New York City, if you advertise a short-term rental, you're subject to a huge fine, okay? And I put on there, they ban unhosted rentals of less than 30 days. So it's very tough to get a short-term rental in New York. And the reason they're doing that is because it's a rent control issue. They don't want folks who live in New York to have to pay an artificially higher rental amount on a monthly basis because it's more enticing to do for an owner, for a landlord, to do these on a short-term basis because they're going to make a lot more money. Las Vegas, that says Las Vegas. There's a typo there. Sorry about that. But Las Vegas, they pretty much ban short-term rentals. And Nevada follows a lot of the laws that we have here in Arizona, but they didn't follow this one. In Las Vegas, short-term rentals are almost banned, and that's because they want to protect the hotel industry. Now, Malibu, California, I thought was an interesting one. They have a season for short-term rentals, and you can rent your home on a short-term rental basis in a certain season when they have a stronger police force at the police stations. They also have an 800 number where you can call and tell on your neighbors if they've rented to some rowdy folks. The one that really gets me though is San Francisco, which is where Airbnb started and still exists. In San Francisco, for a very long time, short-term rentals were banned altogether. And so you're kind of like, well, wait a minute, Airbnb is headquartered here. Why wouldn't they move to Scottsdale, or why wouldn't they move to Phoenix, because it's so much friendlier here? But we haven't seen that happen yet. But so it's somewhat ironic that San Francisco, which is the home of Airbnb, has some pretty significant restrictions on folks. Go ahead and change that one. Now, I mentioned that there's this grandfathering concept. So one of the questions I always get in connection with short-term rentals is, hey, I've got a short-term rental. I bought into this property. The short-term rental was going fine. And now my HOA has decided to amend the CC&Rs to prohibit short-term rentals or to significantly restrict them. And the answer is usually, yeah, they can do that. You bought into an HOA, and the HOA has decided that they're changing their policy, and they go and change their policy. And so a lot of people thought, well, I'm stuck. Now I can't use the property for what I wanted it to use it for. Well, now courts are using this case from 1984, and it pertained to a golf course called the Shalimar case from 1984, where the Court of Appeals said, listen, if you think, or if you are going into a development, or if you are going into a community based on a certain set of facts, and those facts change so significantly that your investment is essentially gone, well, you're grandfathered in, and the HOA or a developer can't do that. Okay, so what happened in the 80s in a golf course in Tempe, everybody thought they were buying on a golf course. They thought that they were going to be putting houses on this golf course. It was going to be a great golf course lot. And ultimately the developer changed their mind and said, no, we're not going to have a golf course anymore. We're going to have more houses. And the homeowner said, no, 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 not so fast. We all bought based on the understanding and the impression that you sold to us that there was going to always be a golf course here. And what the Court of Appeals said is the homeowners are right. They bought based on the representations and based on the belief that they were buying into a golf course community. So what we've done and what other law firms have had to do is say, judges, take a look at this Shalimar case, and we believe that it's persuasive in these situations. If somebody has a short-term rental, they're entitled to continue that short-term rental, irrespective of what the HOA does. Some courts are buying it, some courts aren't. And so the predictive value as to whether that is allowed or happens is quite tough. But that's out there. So there's a grandfathering issue because that question comes up quite a bit. Go ahead and change that one. Okay, so the current legal issues are largely the same, but we've added the misrepresentation issue. We've added the grandfathering claim. We talked about nuisance claims. We talked about injunctions. We talked about the interpretation of the CC&Rs. One of the other items that I wanted to talk about, there are a lot of companies out there who are sort of doing this quasi real estate service where they will connect you with the owner of a short-term rental, and they'll arrange for the cleaning services, and they'll be the ones who get the money, and they'll sort of do the post guest inspections and those sorts of things, but they're not licensed. And so there's a lot of companies out there who are doing this. They're taking a fee, they're getting a service fee to sort of coordinate these short-term rentals. Well, a lot of people are asking, hey, is that allowed under Arizona law? At the moment, it probably is, but there's a California opinion out there from the California Department of Real Estate that says, you're actually providing real estate services. You need a license to do this. I'm not saying that's going to be the law in Arizona, but I wouldn't be surprised if we start seeing a little bit more on that end and looking into what these intermediary or management companies are doing, because a lot of them are not licensed. Okay. The other issue where I see some of this stuff going, Americans with Disability Act, fair housing, okay? Those are the classes you have to take them, apply them to these situations, okay? Under the ADA, right, Americans with Disability Act, there's nothing substantive yet, okay? But these things usually come out pretty quickly, pretty fast. There are these investigators who are out there, they're kind of secret moles that ask a lot of questions and they try to develop cases, and they're doing this on somewhat of an undercover basis, okay? They'll go into communities and see what's going on to make sure that there aren't any ADA or fair housing violations, okay? So under fair housing, again, there's nothing substantive on the topic yet, but we don't believe it's a good idea to, A, decline guests based on, I'm gonna go through the factors, race, color, ethnicity, national origin, religion, gender, marital status, okay? And you also can't impose different terms on those folks than you would on a different set of folks, okay? So there's nothing substantive under FHA or fair housing laws at the moment, but if there's somebody who is discriminating on a fairly large basis against a certain type of person, well, that may be the next trend. Our opinion is that it's probably okay to make a unit available to guests of the host's gender. Meaning, if you're a woman and you have an Airbnb and you want to restrict men from coming into the house, probably okay. It's a safety issue, okay? So that's probably okay. Now, under the Americans with Disabilities Act, again, nothing substantive. We don't have any substantive law on the subject, but I'm going to assume that that's going to be the next trend. And I would assume that short-term rentals are offered as a public accommodation, and therefore the ADA rules apply, just like a hotel. Reasonable accommodations. You can't decline a guest based on an actual or perceived disability, okay? You can't refuse to make a reasonable accommodation. And again, we don't have law on that subject. We don't have an interpretation on that subject, but I think that's where it's going. And so if you're renting your house out on a fairly regular basis, you've got multiple properties and somebody says, I need a ramp, I need something, yeah, I think you're probably gonna have to do it. Now, what we believe is okay under the ADA is to provide factual information about the property so that the guest or the prospective guest can make their own decision. Hey, there's a lot of steps here. Hey, there's X, Y, and Z conditions on the property. You make the determination whether that's suitable for you. So you put it in the prospective guest's hands. But I think ADA and FHA are where these are going. This industry is so hot right now that I think that's an easy target. Okay, next slide. Okay, so based on that, I want to go over some tips very briefly. A lot of them are the same as we had the last time. But number one, you gotta call these folks licensees. If you're calling them a tenant, you may have to go through an eviction action, which is going to ruin the rest of the month because an eviction action can take that long. Okay, so you want to make sure that you're using that critical distinction, calling them licensees, calling them guests. Don't call them tenants. 2, got to do an owner LLC. Have to. You don't want your own personal liability. 3, you got to call your insurance agent. We've seen an uptick, and I didn't include this in the legal trends because kind of maybe it's not so glamorous, but there's an uptick in bad faith litigation against insurance companies. So what happens in a bad faith situation is an insurance company denies a claim, and they're denying claims based on the fact that people are using these as businesses or short-term rentals as businesses. So somebody's trying to invoke their homeowner's policy because a ceiling fan fell, because there was a flood, etc. And the insurance companies are saying, no, you're using this for a commercial purpose, we're going to deny the claim. And so now we see these bad faith claims against insurance companies saying, look, you should have covered my claim, this wasn't a business or whatever. So we're seeing an uptick in those. So let's avoid that by getting in front of the right insurance folks and getting the right type of insurance for these situations. And there are plenty of people out there who offer this type of insurance, okay? Obviously, verify local laws on the City of Scottsdale's initial web page on short-term rentals is a huge frequently asked questions page, and so definitely take a look at that before you change your house into, or before you buy. or you change your house into a short-term rental, look at any recorded documents to see if there's any restrictions that you may want to talk to somebody about. Have a written agreement, and we talked about the importance of a written agreement. I'll give you a written agreement if you need one. There's certain key provisions in every written agreement that you need. I'll go through them very briefly. Number one, you got to have a term. You got to identify the start and end date. And by the way, somebody actually asked me if the term can be in hours. No, you can't rent a home on an hourly basis, okay? It needs to be days or weeks, okay? Don't do hourly rentals. So number one is the term, identify start and end date, and don't do it by the hours. Access, who can access? In an agreement, if you are truly a landlord-tenant, then you can't have access, right? The landlord really can't have access except on an emergency basis or upon 24 or 48 hours notice. Well, we're going to call them licensees or guests. So guess what? In your agreement, you need to have, as an owner, the right to go on the property whenever you want, okay? So we're showing that these folks aren't tenants, right? We want to have occupancy rules. Who are the occupants? Who's allowed to be in there? Are pets allowed? What about common areas? In Airbnbs, you're renting a room. Can I get access to other rooms? You want to make sure that that's spelled out. Smoking, parking, those things, you need to have policies. Damages, indemnities, limitations of liabilities, those are incredibly important. Who's responsible if something gets broken? What if a guest of the tenant or the guest of the licensee gets hurt and they want to sue me as the owner, right? I want to be indemnified from my guest if I ever get pulled into a lawsuit, okay? I want to be indemnified from the person renting from me. And so you want to put that in there. You also want a limitation of liability. I don't know that that's going to be enforceable, but put it in there anyway. Limitation of liability basically says, look, the best case scenario, if you were to sue me as the owner of this property, is that you can get your money back for the rental, your $1,000 or $1,500. That's the best you're going to do. You can't sue me for all these consequential damages. You can't sue me for punitive damages. You're limited to the amount you paid to rent the home or to use the home, okay? You want to talk about maintenance and repairs. Who's responsible for maintaining? Who's responsible for repairing? You want to get into assignment and subletting. These are key terms you want in any agreement, okay? You also want a cancellation or termination provision. What happens if the guest says, I can't make it there? Well, who gets the money? And and what happens to the disposition of any deposit, all right? And again, the key though, throughout that document is that you're calling them licensees, not tenants. Excuse me. So those are the tips. That's what needs to be in the written agreement. The other issue is consider the ADA, consider the FHA issues that we talked about, and then of course have policies for various issues and events. Have a fireplace policy. When can the fireplace be used? When can the pool be used? All that stuff. What happens if you overstay? What is my policy on that? Well, my policy is I'm going to blast my alarm, my home alarm, and then you're not going to have a comfortable time there. So there's different ways you can sort of make these policies work for you and put them out in an agreement. And like I said, if anybody needs a policies and procedures checklist or any sort of checklist, let me know. I also have written agreements that you're more than welcome to use for yourselves. But yeah, a lot has changed. The law has changed. The interpretations of these laws have changed. The interpretations of deed restrictions and HOA documents have changed. And we're starting to see these trends. The trends being more misrepresentation cases on the rise, ADA, FHA issues, and then this grandfathering of issues is sort of coming to the forefront. And we get our laws in a couple of ways in Arizona. Number one, we get them by statutes. And number two, we get them by case decisions or case law. And so either one of those avenues, on the grandfathering, that's probably where we're going to get case law. So it may be a long time before we get some real resolution on the grandfathering. Statutes, as I mentioned, Governor Ducey just signed the bill, which added a little bit more restrictions to short-term rentals, but not much. I think he's really signifying to a lot of people that Arizona is open for business when it comes to these short-term rentals and really promoting that. That's all I've got. I don't know if anybody has any questions.
People always have questions. Let me pull it up. Okay. So, do you need to tell the landlord if you are planning to, so if you're renting and you're wanting to then kind of sublease with Airbnb, do you need to tell the landlord that?
That's a great question. Some people are of the opinion that you tell the land, you ask for permission or ask for forgiveness. Well, I don't know about that. It really depends on the form of lease that you have with your landlord. Under the standard AAR form lease agreement, you can't sublease. You can't assign any interest in the home without the landlord's permission. Okay, so under the AAR standard form lease, which is what a lot of people are, the residential lease, which is what a lot of people are bound to, in a situation like that, yeah, you probably do have to get the landlord's permission. Now, there are plenty of leases out there where the landlord doesn't say anything in the lease. And so the default is things are assignable if there's nothing restricting it. Okay, under Arizona law, if I want to assign a contract, if I want to delegate certain rights, if I want to assign certain duties, I can do that unless there's a written restriction in there. And under most residential leases, there is that restriction, but you can find them out there without that. So to answer that question is kind of tough. It really depends on the form of lease that you're bound to, that you have currently. If you want to sublease it, or if you want to put it on Vrbo or Airbnb, and your lease says you can't do that without the permission, well, then you probably have to get the permission, because what could happen is the landlord will evict you, and then your rental stream goes away. Other people, they don't care about that, and so they say, well, as long as my tenant is paying me, even though they're really not supposed to assign it, I'm not going to evict them because I'm getting paid. So it's a tough question to answer, but under the written contract that you have, it's going to specify whether you can sublease or assign, and if that's prohibited, then you're taking a chance of eviction if you go and do that. But again, other leases out there, they don't say anything about subleasing or assigning. You could probably do it. I don't see the basis for the landlord to evict you if there's nothing in there about subleasing and assigning. Hopefully that answers. It's a pretty complex answer, but I think that's right.
Can a property management company use their own TPT number for all of their properties, or do the owners have to get their own?
Oof. I don't know the answer to that. That's a good question. That's something I'd like to know myself. I don't know the answer to that, but I'll find out.
So with the new law requiring that you give contact information, to whom?
Yeah, we don't know yet. It's probably going to be the county, but we don't know exactly what that database is going to look like and what information they're allowed to collect and how to make that your contact information known. I think those are still in the works.
Let's see. Sorry, some of these questions, they've been cut off and I don't know why.
Well, the other thing too is I think my email address is on there. So if for whatever reason the question doesn't get answered, just shoot me an email. I'm usually pretty quick to respond.
All right. So if you have a short-term rental with grandfathered rights, does that follow to the new owner, or do you?
I would say no. I think the new owner is buying with a fresh slate, and they're subject to what is existing at the time they buy. Okay. And again, that assumes grandfathering applies. There's no definitive sort of rule that says grandfathering applies in all situations. It's really, really driven by each individual judge. And so it's somewhat of a crapshoot as to which judges you get. We've had some judges that are like, yeah, I love the grandfathering argument. I'm gonna allow this to be grandfathered. These guys get to continue their use as a short-term rental. Others are like, nope, you bought into the HOA. You knew that they could amend it. Sorry. And so, yeah, the grandfathering is an interesting one that we're gonna track.
This is more a fair housing question in general, but if the accommodations that you have to provide to be ADA compliant, if those are just onerous in cost.
Again, ADA, we don't know if ADA is even going to apply here.
Okay. So worry about that later.
So, well, I don't want to say worry about it later, but yeah, you're right. I mean, if you have a pool and you have somebody who's mobility impaired, do you have to get a lift so that they go in the pool? Do you have to get these, which could be very expensive? Yeah, I mean, I think that's the reasonable accommodation to be made in those situations. So if it starts trending toward having to make reasonable accommodations, that could put some people out of business, because they're going to say, look, this short-term rental stuff was great, but I'm just not willing to retrofit my house for all of these issues.
So the websites with local municipalities and their regulations, they're just like Scottsdale.org.
Yeah, Scottsdale has got it right there. And the stuff about Scottsdale is that it's very interesting. I think there's a maximum of like 6 adult guests, or there's some weird restrictions, and you're like, wait a minute, in Scottsdale there's no way that people are binding themselves to this or honoring what this code provision says, and that's right, they're not. But there's an interesting restriction. I don't remember what it is off the top of my head, but I think it's a maximum of 6 guests, and it's right there on the Scottsdale website. And you know that people aren't honoring that. And so, and most police officers we've talked to folks in various jurisdictions on how they're policing this stuff, and they're saying, look, if people aren't going nuts, we're not going to do anything. And if they are going nuts, then we'll just break up a party and charge somebody $250. The other issue you may want to consider is, if you're going to do a short-term rental, take your short-term rental agreement down to the local municipality, to the local police department, and say, listen, if somebody is overstaying their welcome at my house and they signed this document, this rental agreement or this license agreement or whatever we're calling it, the short-term agreement, are you going to make me go through an eviction, or are you going to take them away from the house? And so that may preempt you from running into a lot of issues, because I've represented some folks, and they were down in Maricopa or one of the southern valley cities, and they actually had to go through a formal eviction to get folks moved because of language in their agreement. So it's a very unfortunate situation. So I always tell people, talk to the police beforehand, say, is this agreement good? Good, we're done. It'll be signed, and if there's a problem, we can have them removed.
So we're getting lots of questions about whether or not the agreement with the short-term tenant, clients, customers, yes, whether that trumps the lease agreement with their property management. Or...
No, so it can't. Because it's subsequent in time. It's the main agreement is going to be between you and your landlord always. That's the primary agreement that's going to control.
Okay. So also with being the poor guy in the middle between two, do they not have any recourse at all?
It's tough, and those are the ones that I certainly feel bad for. That are just stuck with. You know, there's a strong argument that says, listen, this is affecting the integrity of the neighborhood, and this is, you know, I don't feel safe. I don't know my neighbors. I fully appreciate that. What those folks can do, and to be clear, I'm not pro Airbnb or pro short-term rental. I'm just here saying this is a really interesting concept in the law right now. We're at an interesting sort of period in time. And Arizona seems to be a pretty friendly state compared to a lot of other states. So I don't want to give the impression that, hey, I'm doing this all over the place, or you should do this too, or anything like that, because I know I have them in my neighborhood, and I know that it does affect harmony in some fashions or in some instances. So the way in which people who are affected by these can kind of do something is to talk with the other neighbors and see if there's a deed restriction or something that everybody can come up with and live with and record it so that this stuff doesn't happen. That's all I can really think of. You know, filing nuisance claims may work. It's just tough. right now the economy or the sort of feeling is to promote these, and the courts are allowing the promotion of these and the proliferation of these. And so for those who are affected, who don't like this, it's tough. And it's banding together with other neighbors and doing the best you can to try to discourage this from happening, or to do it in a more responsible way, because other states are doing just fine with it, and they've got more restrictions. And so I'm not always in favor of more restrictions on anything, but I think Arizona could do a little more, maybe, to at least protect some of the neighborhoods.
So this is an interesting one to go along with that.
Mm-hmm.
The person writing in had a short-term rental in a non-HOA neighborhood in Scottsdale, and then the neighborhood got together and amended the 1950s CC&Rs to limit the short-term rentals to 60 days, and they were advised to sell and get out because it was just
interesting. Yeah, I'm just reading the question up there. I think I can see it.
Okay.
Yeah, so let me just make sure I understand this. There was a deed restriction from the 1950s, or a set of CC&Rs from the 1950s. Ultimately, a group of the neighbors got together, had the requisite vote or a number of approvals to change this such that short-term rentals would be more difficult. Yeah, that's an interesting one. If you have a short-term rental in a neighborhood like that and your neighbors are against you, then yeah, it's probably a good time to move. Now, anytime you have a set of CC&Rs from the 1950s, I'd put up a little bit of a fight. And the reason I say that is because restrictions from the 1950s are going to be so much different. The times have changed so drastically that some courts will be inclined to say, look, these conditions that sort of gave rise to the 1950s CC&Rs or deed restrictions, they just don't even make sense in today's world. And so I'm going to abandon, or I'm going to deem abandoned, these old 1950 ones, these 1950 restrictions altogether. So yeah, there could have been a fight there. That's an interesting one. We've been able to successfully invalidate deed restrictions because of their age and because they didn't contemplate some of the things that neighborhoods are going through now. And so in the situation that question came up under, the issue is, well, were those 1950 CC&Rs or deed restrictions valid in the first place? And had you been able to prove that they were invalid in the first place or of no longer any real effect, then that amendment would have never been allowed. I don't know if that answers the question, but there's always a fight there. There could be a fight there and say, look, these are so old, they don't even make sense. Therefore, the amendment provisions don't make sense. Therefore, they need to go away. And we need a judicial declaration saying they don't make sense.
There seems to be some question about what's grandfathered and what isn't.
Sure. So grandfathering. The grandfathering means your ability to continue a particular use with your property, notwithstanding a new change of the law or a new change of the CC&Rs. So for instance, if my current set of CC&Rs says nothing about short-term rentals, and I'm using my property as a short-term rental and I'm making money on my short-term rental, and the neighborhood bands together and says, we want to amend the CC&Rs to change, to restrict short-term rentals, meaning we're going from no restriction to a complete restriction, and I'm stuck in the middle because I've got this, I'm using this as a short-term rental. Well, the law says, or the law may say, even though the change happens, and even though there's a legal vote to change the CC&Rs to prohibit short-term rentals, I still get to use my specific property for short-term rentals. So I'm grandfathered in. I'm allowed to continue my use now that it's, even though that's now non-conforming, okay? I don't know if that explains it, but that's what grandfathering usually refers to, is you're grandfathered in. You get to use the laws as they existed when you purchased, as opposed to the laws that have now since changed. And so we don't know if grandfathering actually works, right? We've had a couple of judges in Maricopa County say, hey, we're persuaded by this argument. The normal rationale is that, listen, you buy into an HOA, the HOA changes their mind, or that changes their governing policy and says you can no longer do short-term rentals. Well, the fact that you had a short-term rental is now gone, and you lose your investment essentially. You lose your right to do short-term rentals. Well, now courts are saying, actually, maybe you were grandfathered in. And so we have this difference in opinion in judges. Some are saying the grandfathering works and you get to continue your use. Some others are saying, no, you bought into an HOA, you knew they could amend the CC&Rs, you're therefore amended, and you can't use your home as a short-term rental. So the grandfathering is something that we're watching because it's we don't really have any definitive law on it.
So we're getting a lot of specific questions about, essentially how to write the agreement.
Mm-hmm.
So I am going to say definitely reach out to
an
attorney for that.
Yeah. So we have checklists, we have agreements, we have sort of policies. Yeah, I mean, they're fairly comprehensive, and yeah, you want to get those professionally looked at. Some people kind of wing it, and they may have some success doing that, but I'd probably, if you're doing this on a fairly regular basis, or you're doing this as a business, a lot of people are turning this into business. They're buying 3, 4, 5 at a time. And the other interesting thing is that I've heard that lenders right now are saying, listen, if you do short-term rentals, all we're going to do is look at the comps in the neighborhood that do short-term rentals and base our lending decision on that. And so you can actually base their underwriting on other short-term rentals. So you can actually get financing for these. So it's just becoming so popular. But in any event, I would recommend you have somebody take a look at this, sort of give the attorney or give somebody guidance on, hey, I want to use this on a short-term basis. I want to do this for 6 months. I want to do this for 9 months. Here's what my property has. Here are the concerns I have. Can you put together an agreement, or do you have an agreement, or can I see an agreement? And I'm happy to show you, what we use in the general sort of very basic situations. Each situation is different, but we have documents that are going to apply to most situations.
Great. Well, we're out of time, so I wanted to thank you again, Patrick, for being here. If anybody has any questions, please feel free to contact him. The contact information is on your screen. Also, to reassure you, yes, this is being recorded, and I will be sending this out in an email to everyone, hopefully by tomorrow. And we want to thank you for being here, and we hope to see you again soon. So have a great day.